Well, New York State is at it again. The Department of State has just issued new guidance and new interpretation of the 2019 Statewide Housing Security and Tenant Protection Act. And it's having a major impact on landlords and brokers throughout the state, and especially in New York City. In response, several trade groups as well as brokerages have filed a lawsuit to stop the state from implementing its new interpretation. In this video, I'm going to talk about the new guidance, what it means, as well as cover some of the arguments in the lawsuit and the likelihood of its success. Coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoy the content in this video, hit the like button and comment down below. Now, as always, whenever I talk about legal concepts, just know that I'm not providing legal advice, and you should always consult with your own attorney and your own advisor before making any legal or financial decisions. Just know that the laws are constantly changing, and that even if something that was said in a YouTube video was correct at the time, it doesn't mean that it's going to be correct in the future. So for that reason, definitely consult an attorney who can understand your specific situation and give you specific and tailored advice. Last but not least, the views and opinions that I express in this video are my own alone and do not necessarily represent those of my law firm or any of my business partners. In order to give the current controversy proper context, we first have to look at the changes to the Landlord-Tenant law that were enacted last summer. This was the Statewide Housing Stability and Tenant Protection Act of 2019. The legislature passed that law in June of 2019, and that law implemented numerous changes to the landlord and tenant relationship, including evictions and rent regulation and various different provisions. One of those provisions in the law related to the fees that a landlord can charge tenants. I covered a lot of the changes that were implemented at the time in a separate video. I'll link it in the description if you guys are interested in checking it out. One of the provisions that was created by the new law was Section 238-A of the Real Property Law. That section set out restrictions on what kind of fees and how much a landlord can charge a tenant. Specifically, that section provided that no landlord, lessor, sublessor, or grantor may demand any payment, fee, or charge for the processing, review, or acceptance of an application, or demand any other payment, fee, or charge before or at the beginning of the tenancy, except background checks and credit checks as provided by paragraph B of this subdivision. Paragraph B, in turn, provided that a landlord, lessor, sublessor, or grantor may charge a fee or fees to reimburse costs associated with conducting a background check and credit check, provided the cumulative fee or fees for such checks is no more than the actual cost of the background check and credit check, or $20, whichever is less. So in short, what this provision said is that a landlord can no longer charge an application fee or other types of fees except for background checks or credit checks up to a maximum of $20. Since this provision was enacted in June 2014, most landlords have switched their process and have stopped charging tenants fees that were prohibited by this statute. The interpretation of this provision at the time and up until now did not include or involve the broker fees that may be charged and collected by real estate brokers in connection with renting apartments for landlords. However, that all changed on February 4th, 2020, when the Department of State issued its guidance providing an interpretation of this specific section as it pertained to brokers' fees. In a single paragraph Q&A format, the Department of State has issued a new interpretation of this section. And this new interpretation stated, question, can a landlord's agent collect a broker fee from the prospective tenant? The answer is, according to the Department of State, no. A landlord's agent cannot be compensated by the prospective tenant for bringing about the meeting of the minds. citing the Section 238-A-1A of the New York Real Property Law. The Department of State says that, in part, that section provides that no landlord, lessor, sublessor, or grantor may deem any payment, fee, or charge for the processing, review, or acceptance of an application, or, in bold, demand any other payment, fee, or charge before or at the beginning of the tenancy, except background checks and credit checks. The Department of State goes on then to say that the fee to bring about the meeting of the minds would be, quote, a payment, fee, or charge before or at the beginning of the tenancy, other than a background or credit check, as provided in this section. Accordingly, a landlord's agent that collects a fee for bringing about the meeting of the minds between the landlord and tenant, i.e. the broker fee, from the tenant can be subject to discipline. So what the Department of State is saying here is that they're interpreting this section of the law to prohibit brokers from collecting a broker's fee from a tenant when they help the landlord rent the apartment to that tenant. Now, what the Department of State has also said is that brokers are not prohibited from contracting with tenants and from tenants hiring brokers to help them find an apartment. And in that type of arrangement, the broker's fee can still be collected. It's the situation where the broker was hired by the landlord to go ahead and market the apartment and find a tenant for them that they're prohibited from collecting a broker's fee. Now, the issue that this has caused to the real estate industry is that in places like New York City, it is a common practice for brokers to collect commissions from tenants as opposed to landlords. Now, according to the brokerages and the trade associations that filed the lawsuit against the state that I'll talk about in a minute, there are thousands of agents across the state and in New York City that rely on this type of arrangement to make a living. And so what this did is that as soon as the Department of State has issued this guidance, that basically made all of those transactions and all of their activity illegal. So what's happened as a result of this new interpretation is that a lot of the tenants that have previously agreed to pay the fees and have entered into agreements with the landlord and the broker to consummate those transactions are now backing out of the deals. There's been a lot of news coverage with articles in the Wall Street Journal, the New York Times, the Daily News, talking about this interpretation and saying that the Department of State has now made it illegal, that the tenants are recognizing this and they are backing out of their deals. Additionally, tenants that have already paid these commissions are now coming back to the brokers and saying, you have to refund me the commissions because they were illegal and you shouldn't have collected them. So as you can imagine, this has created a tremendous amount of anxiety and turmoil in the real estate industry, because thousands of agents now across the state are being told that the way that they make their money, the way that they make a living is illegal. And what's happening is that a lot of these agents could possibly go out of business because the landlords who are now burdened with having to pay those commissions are probably not going to pay the agents, and they'd rather go and try to rent the apartments themselves, use their staff, or use other resources. So in response to all of this, the New York State Association of Realtors, as well as another trade association and several large brokerages have filed a lawsuit against the state. And the lawsuit is basically asking the court to do two things. The first is it's asking the court to stop the Department of State from proceeding with implementation of this interpretation during the pendency of the lawsuit. And the second thing that the lawsuit is asking the court to do is to issue an order saying that this interpretation by the Department of State was an invalid regulation and basically to make it null and void. So as of today, at the time of this recording on February 13th, 2020, the court has signed what's called a temporary restraining order prohibiting the Department of State from implementing this interpretation, as well as prohibiting the Department of State from imposing any disciplinary actions against any agents engaging in this transaction until it decides the merits of the case. So as of right now, the broker's fees that are being collected from tenants are 100% legal. It's status quo, and tenants are supposed to continue to pay the commissions as agreed per the contracts which they signed. And so I want to talk a little bit about the arguments that are being made in this lawsuit. So the first argument that the petitioners are making is that the Department of State, at the time that it issued its interpretation, actually created a new rule or a regulation. And it did so without following the proper procedures as required by state law. In New York State, there are two ways that a government can impose restrictions or regulate conduct of its citizens and the public. The first way is for the legislature to pass a law, and then that law gets signed by the governor, and that creates a statute which provides the regulation or the restriction on private conduct. The second way that the government can do this is through an administrative agency issuing a rule or a regulation. But in order for the administrative agency to do this properly and legally, they have to provide a notice and a comment period to the public, allowing various stakeholders to voice their opinion with regard to the regulation or the rule that the administrative agency is proposing. The other thing about rulemaking and regulations is that they're not supposed to create new laws, because that is the job of the legislature. It's not something that an administrative agency is supposed to be doing. So regulations are supposed to interpret statutes passed by the legislature and signed into law by the governor, and not create new ones and not add something to statutory language that isn't already there. And so the argument in this case is that the Department of State failed to follow the proper procedure. It didn't notify anybody, it didn't notify the stakeholders, brokers knew nothing about it, simply issued this guidance, put it on its website, issued a press release, and all of a sudden became the rule. So that's the first thing that the petitioners are arguing in this case. The second thing that they're arguing is that even if you can excuse the failure to provide the proper notice and comment period, the interpretation itself violates the state statute, because according to the petitioners, there is nothing in the state statute that would impose any requirements on brokers. So as I read to you earlier, the statute only purports to regulate the conduct of the landlord, the lessee, the sublessee, and the grantor. It doesn't say anything about brokers. And so the petitioners are arguing that brokers, being a separate individual, a separate party in the real estate transaction, they are not regulated by this law. And when the Department of State imposes this new interpretation, they're actually going outside of what's allowed by the statute, and they're violating the statute, and their interpretation is in fact erroneous, illegal, and irrational. The Department of State and the Attorney General has yet to file an answer and reply to the arguments that were made in the petition in this lawsuit, so it remains to be seen what they'll say about this. But I suspect that what they will say is that the Department of State did not create something new. All it did was interpret what was there and simply infer from the language that any agent of one of those four parties was subject to the requirements of this law as well, which means that the broker, as the agent of the landlord, would be subject to restrictions on the fees that the broker could charge. Now, of course, the counterpoint to that, and is something that is already addressed in the papers submitted by the petitioners in this lawsuit, is that the legislative history of this particular statute did not mention anything about there being any restrictions on brokers making commissions. According to the petitioners, there was no discussion among any of the legislators in the process of debating or voting on this legislation that talked about brokers. And they will say that the Department of State's argument that this was simply an inference that they were making from the statute is completely baseless, and it should not be allowed. Personally, I think that the arguments made by the petitioners in this lawsuit, the brokerages and the trade associations, are valid. I really think that the Department of State really made a blunder here. I think they rushed something through that wasn't very well thought out. I don't think that it's very well supported, and it seems like they didn't even consider the impact that it will have on thousands of people, on agents, working in the industry, and essentially putting them out of a job. I don't think that they were anticipating this type of backlash. I don't think that they were anticipating this type of impact. But of course, the matter is now in the hands of the court, so we'll see what happens. I do suspect that if the court rules against these trade associations and brokerages, that there most likely will be an appeal. And so this matter is not likely to end anytime soon. And I also suspect that the restraining order and the preliminary injunction prohibiting the Department of State from implementing this new law is going to remain in effect as long as we have litigation, as long as the matter is in the trial court's hands, and then if there's an appeal, all the way up through the appeal process. So most likely this is not going to be implemented anytime soon, but time will tell, and obviously I'll keep an eye on this and I'll give you guys an update if you're interested in it. And if you guys have any questions about anything that I mentioned in this video, drop a comment down below. I try to answer all the questions that come in, so I'm happy to do that. Or if you have any other thoughts or your own opinions on this, definitely let me know there as well. If you guys enjoy this video, hit the like button. If you like this type of content, subscribe to my channel. I do videos on legal concepts as well as real estate investing strategies. So if you're interested in that, definitely subscribe. Thanks for watching, and I'll see you guys in the next video. Take care.